Thanks a million for taking the time out of your day to join our Essential Skills webinar this month. So this month we are looking at an introduction to intellectual property and IP management, and that's with our speaker today, Donal O'Connell. Donal's going to introduce himself, so I'll just cut straight to our housekeeping for today's webinar. So as per usual, there will be a bit of time at the end for our Q&A session. And if you have any questions for Donal that you'd like to ask, please pop them in the Q&A function in the bottom toolbar on Zoom as we're going along, and we'll remind you of that towards the end. Also, if you are experiencing any technical difficulties today, please use the chat function for that. So myself and Alex in the background will be moderating the chat function. So we'll be keeping an eye on anything like that. But if you can't get access to the chat function, please email us or call the number on screen there now. And at the very end, we'll have an online survey that you'll be directed to. We really appreciate you completing those surveys at the end of these webinars because the feedback is extremely valuable. So please do, if you can, take the time. And just as well to note that obviously this webinar goes towards your CPD, so please record the 1 hour on your CPD record. And just a note, I'll remind you again at the end, but Donal will also be providing a masterclass or a full day online classroom in intellectual property for engineers. So it'll obviously be a deeper dive on what he'll be covering here today. And we'll be popping the link in the chat for you to register for that. And that will be held on the 2nd of October. So I think that's everything from me. So I'm going to pass over to Donal to get started. Thanks a million.
First of all, I should start by saying I'm not an attorney. I'm actually an engineer, worked with companies like Atari and Philips and Nokia, then went up the traditional engineering career ladder for many years, became VP of R&D at Nokia, set up a greenfield site in Texas and was there for many, many years. But over time got dragged into IP. So I've been in IP now for over 20 years. I run an IP consultancy and software company. I teach at various universities. I write regularly about IP, a number of books and papers published. So hopefully what I've learned and what I'm going to present to you today makes sense. But I should stress that I'm coming at IP perhaps from an unusual angle, and that many people who present an IP are attorneys. We're going to start with a definition. What is it? If you look at the formal definition, if you go to the World Intellectual Property Office in Geneva, the sort of global entity that coordinates IP, it talks about IP referring to creations of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images used in commerce. So its definition is based around the fact that it's made up of different things. And that's often the case you'll see with IP. It's actually an umbrella term. It's made up of different forms. If there was an attorney presenting to you today, they would probably say, well, it's a legal matter. There's laws, rules, and regulations, and they would talk about the legal aspects, and that's a fair comment. A strange definition I've come across is it's a form of limited monopoly, and normally monopolies are frowned upon, but actually in the case of IP, it's a legitimate form of monopoly. It allows you to do something and stop somebody else doing something. However, if we were to invite in somebody from a finance or accounting or a tax background, they would probably give a very different definition of IP. They would say it's an asset class, just like houses or cars or stock. It has all of the attributes of an asset class. And actually, if you look at financial standards, there are standards or subcategories of standards there that talk about intangible assets and IP as from a finance point of view. That's also a fair definition. IP sits between the worlds of business and the law. So it's not surprising that depending on who you're talking to, you're either getting a more business perspective or a legal perspective. And the one that I prefer more and more is I see IP as a management system for innovation and creativity. obviously, if you're involved in innovation and creativity, you need to understand what is it, what is being created, who can use it, who can access it, and IP helps there. But all of these definitions are valid. So there's no one simple definition, and I think it's worthwhile just briefly understanding what it is. It has different characteristics as well. So sometimes when you have some IP in your possession, it looks like you've got a sword in your hand. You can use it to attack others. Other times it looks like you've got a shield in your hand. You can use it to protect yourself. If you get into IP, actually at times it looks like you're involved in a game. It's like you're playing a very complex game of chess with many more pieces on the table than normal, and lots more people across the desk from you than just the one typical opponent. So it has attributes of gaming. It has a stickiness, a glue, and certain aspects of IP remind you of that. Perhaps the form of IP that resonates here is perhaps as trademarks, and you see, I know it, for example, my daughter, she is very much into her brands and her logos on her t-shirts and her shoes and so forth. So there's a stickiness that attracts her to certain aspects of a product or a service. I mentioned already about it being an asset, but on the reverse, just like many things in life having value, they also have risk, and IP is also a source of risk. Yes, it has the legal characteristics, and last but not least, it's a great source of data, which we'll look at later on in the talk. So it has different characteristics. Why am I encouraging you to spend some time thinking about IP? There are lots of arguments, but perhaps one that illustrates the point. In the 1970s, there was a survey done on the value of companies, and they looked at the Fortune 500 companies and to explore what made them valuable. And about 80% of the value of those companies at that time was made up of the fact that these companies had tangible assets. They had trucks, they had warehouses, they had desks, they had tables, they had stuff that's tangible in nature. And the rest was made up of intangibles of one sort or another. But the main reason they were in the Fortune 500 was they had lots of tangible assets. The research was repeated in the early noughties. Obviously, not the same 500 companies. Some companies had added to the list, some companies had dropped from the list. But the results were reversed. What was making these companies valuable was the fact they had intangible assets: brands, relationships, software, data, patents, trademarks, etc., etc. And only 20% of the value was made up of the fact they had tangible assets. In fact, if you look at innovative creative startup companies, often you'll find that, forget the 80%, the value of these companies is often much closer to the 100% when you look at their intangible assets. So the reason why IP and perhaps the broader intangible assets have to be looked at is it's what's making companies valuable. If you look at one of the most valuable companies, Apple, yes, they have a nice building, no doubt about it, and they have probably nice desks and chairs, but that's not what makes them valuable. It's the brand, it's the relationship, it's the way they coordinate their app store, it's their patents, their trademarks, their software, their data. That's what makes them one of the most valuable companies. After all, Apple, one of the most valuable companies in the world, doesn't make its own phones. They're made by a subcontractor. They often don't make many of the components in their smartphones. They're made by companies like Apple, like Philips and Sanyo and Seiko. If you look at the App Store and the software, vast majority of it's made by small software companies. Even some of the software is made by their competitors. So the most valuable company in the world doesn't make their own smartphones, doesn't make the components, and doesn't make the software. Okay, I exaggerate a little bit, but what makes them valuable is something else, their intangible assets. Now, going back to the definition by WIPO, they talk about the different forms of IP, and there are many different forms. Some get more coverage than others. This list lists probably a dozen or more of them. They're probably items I've neglected here, but these are the vast majority. I should stress that the order they're displayed in is not indicating that one is more important than the other. I'm not saying patents are the most important form because they're first on the list, but it's a form of IP that gets a lot of coverage. Patents protect inventive ideas. Copyright protects artistic works. Trade secrets protect valuable business confidential information. Employee know-how, somewhat linked to trade secrets, protects information that's in the heads of the employee that may not have been documented. Domain names is your address on the online world. Database rights protects the way you sort or manipulate data in a database. A grant or a license might be a license granted by, for example, a government authority to allow you to do something. Semiconductor topography protects the 2D or 3D designs of integrated circuits. Traditional knowledge protects rights that have been gathered by people in certain locations or because of their history and so forth. Trademarks protects the name or logo, plus a few other aspects that they do with a product or a service. Designs protect the shapes, the ergonomics. Agreements and contracts, which often include IP provisions, are the rights and responsibilities that parties have agreed between themselves. Confidential information, somewhat like trade secrets, perhaps not to the great degree, not to the same degree in terms of value. Social media handles is your presence on various platforms, your LinkedIn, your Facebook. Geographical indications protect something that perhaps links its quality to a particular location. Image rights, perhaps more associated with celebrities, and moral rights linked to copyright in terms of who can use your artistic work. So there are various forms, and one aspect of managing IP or understanding IP is understanding what are these different forms of IP, what can they protect you, and how can they protect you, but what are their limitations? A lot of coverage is given to what we call the big five: patents, trademarks, copyright, designs, and trade secrets. And oftentimes, if you go to IP training, these get a lot of the coverage and perhaps the others are neglected. But I would say, really, you have to go back to the original list and say, well, in my business, what is the nature of my innovation and creativity, and which forms make most sense to me? There are certain forms may not apply at all to you because of the nature of your work. But clearly, you should have a good understanding of these if you're involved in engineering. One challenge, however, is that once you get your head around these different forms, they all have their oddities and idiosyncrasies. Sometimes this is due to the fact that these forms of IP have been around for a long time. First patents are from the 1400s, first trademarks from the 1890s, copyright from the time of the printing press, although there's evidence in ancient Irish history that there was some form of copyright in the times of the druids and the kings and the monks. Some forms require you to register. You've got to go and knock on the door of the patent or trademark office and apply. Others, there's no interaction with the government. Some forms, once you create the innovation or creativity, you have it. Copyright. Once I write my book or once I create my song, I have copyright protection. Other forms take some time. Patents may take 2, 3, 4, 5 years to get it. There's a few forms that give you a choice. You can go registered or unregistered. Trademarks, they exist in both forms. Designs, they exist in both forms with pros and cons as to which way you would go. Some forms of IP protect you against infringement. Somebody doing what you have captured in your IP. Others only protect you against misappropriation or theft. The other party has to steal from you. So, linked to that, some forms are useful against independent creation, others not. One form has a use it or lose it. Trademarks, you have to use it within a certain period of time. Otherwise, there's a danger that you lose your IP. Other forms, for example, patents, there's no use it or lose it. You have the patent so long as you pay the appropriate fees. Some are published. In other words, I can see what you're up to, and so can everybody else. Other forms, there's no publication, so it's secret. And just when you get your head around all of these oddities and idiosyncrasies, be aware that at the moment, most forms of IP are undergoing changes. We've had a period of patent reform, particularly in the US in the last few years, dramatically changing certain aspects of patents. We have had discussions about copyright, particularly in the digital world. Trade secrets have gone from being something neglected prior to about 2015 to suddenly becoming a really important form of IP thanks to law changes. So that's the most common way to look at IP. It's made up of different forms, and you've got to learn about each of the different forms. However, it's not the only way to slice and dice the world of IP. You can also look at IP as made up of a number of key activities or processes you have to master if you're going to be good at it. And there are 5 you've got to be good at. You've got to first of all understand, how do you create the stuff? Once I have an innovative, creative idea, how do I get to the point where that's now protected with some form of IP? And the creation process will depend on the form of IP. So the creation process for copyright is totally different from the creation process for, let's say, patents. Patents is probably the most complex of the creation processes. But once I have this IP, and if you're anyway innovative or creative company, you're likely to have lots of this stuff. You've got to then master the second process, which is portfolio management. It goes by different names, I must admit. But how do I look after my assets once I have them? The same way, if I had a collection of houses or a collection of cars, I have to look after them with tender, loving care. Maybe one of the houses I own has got a broken window, or I need to pay the insurance, or I need to fix the roof. Well, if I have a collection of IP assets, they require tender, loving care. In some cases, they require maintenance fees to be paid. So it is, how do I make sure that my assets are still valid to me, adding value and relevant to my business? Thirdly, I've got to learn how to enforce these rights. In most cases, that's up to the IP owner. I'm down in South Kerry at the moment. If I ring up the local police in Castlemaine police station and say, I'd like to report a crime, my trademark has been infringed, the local policeman will probably tell me politely to go away and say, we're busy chasing bicycle thieves here in Castlemaine. You've got to do it yourself. There's a few exceptions where the white collar crime fighters will get involved, maybe counterfeit products coming across a border, quite serious trade secret theft. But in most cases, you've got to enforce your rights. You've got to first of all be able to detect that somebody has misbehaved, and then you've got to figure out, okay, how do I resolve this to a successful resolution? Fourthly, I've got to be able to exploit this IP. I've just spent this time and energy and perhaps money investing in creating this portfolio. How do I make sure it adds value? And there are various ways that IP adds value to the business. So I've got to absolutely make sure that it's benefiting whatever my business is doing. And last but not least, I've got to be good at risk management, because you're unlikely to be the only person playing this IP game. Others out there will have IP. And of course, the risks aren't just to do with your competitors. The risks might be much closer to home. I'm not accusing any of you on this call of it, but employees might be doing things. They might be stealing your trade secrets once they leave the company. Your suppliers, your collaboration partners, your customers might not be completely complying with the IP provisions in the agreements. Yes, your competitors might be up to no good. Maybe the risks are even further afield. Maybe hackers from North Korea are trying to break into your company and steal your valuable trade secrets. So you've got to understand risk management. How do I detect risk? How do I analyze the risk? How do I make decisions that guide me in terms of how I'm going to mitigate the risk? So a second way you have to look at IP is the fact it's made up of key activities. And it's not just about creating the stuff. Nobody, for example, would build a house without having a plan as to what they're going to do with the house. Are you going to live in it? Are you going to rent it? Are you going to sell it? Well, the same with IP. When you create this IP, you think I have a plan to do with how am I going to manage it, enforce it, exploit it, and so forth. I mentioned about exploitation and the fact that there are different ways of getting value. The direct use is very much is leveraging the sword and the shield analogy I talked about earlier. You're using it to really ensure you're competitive. The indirect use is more looking at IP as an asset. Yes, I can sell it, I can license it, I can franchise it, I can merchandise it, I can use it to underpin a joint venture. And then there's actually other ways. For example, these days you can use it to get tax benefits. The Knowledge Development Box in Ireland, the Patent Box in the UK, is where you can benefit by paying less tax by showing the government that you have IP that underpins your innovation or creativity. So there's multiple ways to exploit your IP. A third way to look at IP is what I call IP models. And a model is simply, in this case, the relationship that exists between you and another entity or multiple other entities. So it's, what is this relationship from an IP point of view? And there are multiple models that you can embrace. So for example, if I have IP and I license it to one of you on the call, I'm the licensor, you're the licensee. That's the model. And we will probably have a license agreement of one sort, outlining the rights and responsibilities of both parties. That's a model. I could sell you the IP. I'm the seller, you're the buyer. That's a relationship. I could give you my IP away for free. It might sound strange, but some people do that. They're probably the most common models you come across. However, there's other models. You might be short of money and you're looking for investment. And I'm an investor, a VC, a private equity, a bank, and I'll give you the money. I'll invest in your business, but I want your IP as collateral. There's a model. I'm the lender, you're the lendee, but IP is in there because I'm only willing to lend to you if you've got good IP and you're willing to use the IP as collateral. Litigation funding. You're involved in a dispute, patent dispute. I don't know the numbers for Ireland, but a patent dispute in the UK is going to cost you £1 million. A patent dispute in the US is going to cost you $10 million. You don't have $10 million, but I'm willing to back you in the dispute. So I'll fund your litigation. There's an example of a model. Then some models that have emerged in recent times, particularly out of academia. Open source software, that's a model. You might not think of open source as an IP, you might be thinking that's pure software. But if you look at any if you look at any open source software license, you realize very quickly you're dealing with an IP license, mainly copyright, but not always to do solely with copyright. So the software, open source software model is underpinned by IP. Creative Commons to do with more artistic works, open access to do with more data, the green and yellow license models there. Going a little bit further into models, I suspect many of you are on LinkedIn or Facebook. I don't know how many of you have read the terms and conditions of use of any of these platforms, but it's quite interesting if you do, because in many cases, you're looking at almost like an IP license agreement. Facebook has a terms and conditions of use. In essence, it says, hello, any IP that you provide, such as text, videos, images, we're free to use. Have a good day. Now that to me is an IP model. Facebook doesn't ask you about your car or about your house or anything tangible. It asks you about your intangibles. And the terms and conditions of use is all to do with your intangibles. A spin out from a university is very much underpinned by the IP that the university makes available to that spin out to survive. Franchising and merchandising, they are IP models. Sponsored research, I'm going to pay you, you're going to do research for me, I get your output. Your output is likely to be in some form of IP. So there are various models that exist. And you've also not only do you have to understand the forms of IP, the processes, you've also got to understand which models make sense to my business and which ones am I going to leverage, which ones am I going to avoid like the plague. They basically have no relevance to my business. Hopefully you're okay with the pace. We're going to change direction and look at some IP management concepts briefly. These concepts all emerged in the 1970s thanks to research that was going on about IP management. Nice fancy slide, but in essence, this basically is saying, in the world of IP, there's an IP maturity ladder. Just like in the world of soccer, there's a league table. So if any of you are familiar with UK soccer, you'll recognize that there are teams in the top like Manchester City, Arsenal, Chelsea, etc., etc. And then the teams down the bottom, like Doncaster Rovers or Scunthorpe. And you clearly can tell from that league table that some teams in the top are good and some teams down the bottom aren't so good for whatever reason. And this IP maturity ladder, in essence, says the same about companies and IP. Some companies are good at this stuff. IP pervades the organization. There's a sense of activation about IP. It's taken seriously by management. There's metrics, there's budget, there's attention. And then there's teams on the bottom, or companies on the bottom, who have a very passive approach to IP. You could even say there are companies on the bottom who can barely spell IP. Poor recognition. They don't take it seriously. And this is a very top-level view of that research, but it basically went through and explored what is it that makes companies good or mature or sophisticated, and what is it that makes companies poor, and what are the implications of that? So for any company, I would say it's always good to know where you are. I would say it's good to know where you are in the league table. And are you happy with that position? Or do you want to move up the league table? And then do you know what's involved with moving up the league table? So this research was about looking at companies, putting a mirror in front of them to look at where they are. A second piece of research looked at industry sectors. Now we're not looking at one company, we're looking at all the companies in a particular industry sector. And it basically said, if you look at any industry sector, a company is in one of four quadrants. They're in the goldfish quadrant, which is the IP value of that company is very low, but their IP risks are low. They're a goldfish. Then you have companies who are targets. Their IP value is low, but they have high risks. Then there are glasshouse companies, which are companies that have high IP value, but they also have IP risks. And then the sharks are companies that have high IP value and low IP risks. Now, because it's a simple 2x2 matrix, any company must be in one of those four quadrants. And the other companies in your sector are in one of those four quadrants as well. So this is about understanding your relative position against others in your ecosystem. Now, why do you want to know this? Well, if you're a goldfish and you're competing with, say, a glasshouse, that has a very different competitive look to it compared to a goldfish competing with a goldfish. Or, for example, a goldfish wanting to do collaboration with a shark, that discussion is going to be very different to a goldfish type of company wanting to collaborate with a target. So knowing where you are and knowing where you are relative to everybody else is quite useful from the competitor analysis point of view, but it's also really useful if you're going to get involved in collaboration of one sort, either a supplier relationship, collaborative innovation, or a supplier-customer type of relationship. You want to know what the other party is thinking and how they're going to help resolve any IP issues that arise and so forth. Again, this work started in the 1970s and has evolved subsequently. The third piece of research is relatively newer, and it's looking at the fact that more and more companies these days have lots of agreements. You'd be surprised how many companies have tens, hundreds of thousands of agreements. Everything from employment agreements, subcontractor agreements, NDAs, materials transfer agreements, service level agreements, agreements with Facebook or Twitter or whatever because they're using that platform, etc., etc., etc. So you can have lots of agreements. And in some of these agreements, you're the controlling party. You drafted it. You wrote the agreement in such a way it benefits you. But in many times, you have agreements that are drafted by the other party. Maybe the other party is a bigger entity. They insist on you using their standard terms and conditions. Or maybe you had to take the agreement and just that was it. For example, if you use Amazon cloud-based services, automatically the Amazon cloud-based services agreement kicks in. You don't go back to Amazon and say, I'd like to negotiate it. They say, that's the agreement. Take it or leave it. If you use open source software and you have a particular piece of software you're interested in and it comes with a GPL license, that's it. Now, what has these agreements got to do with IP? Most of these agreements contain IP provisions. Some are obvious, some not so obvious, and some are quite hidden away. I mentioned, for example, there about Amazon cloud-based services. Now you might say, oh, that's an IT agreement. It's got nothing to do with IP. Except if you read through it, you'll come across a section called IP. And in there, it basically says, if you use Amazon cloud-based services and you have IP that relates to cloud-based services technology, you can't use your IP against Amazon. Have a good day. That's in the Amazon cloud-based services agreement. You can't enforce your IP against Amazon. Now that to me means you've just given them a license. You've allowed them to use your IP. So this concept is about understanding what are all the agreements I have? What are the IP provisions in these agreements? And how does it influence the direction of flow of my business? By the way, I'm not saying there's anything wrong with having agreements where you're being controlled. In many cases, you'll have agreements where you have to live with the terms and conditions, so long as you go in with your eyes wide open and you understand what you've just signed up to. And then the fourth concept is very much about the fact that the risk environment for companies varies greatly. I won't go into so much detail here, but it basically says you've also got to understand your risk profile and that there are different environments you operate in. And understanding that and understanding what actions you then take to mitigate those risks is important. So these are management concepts that started life in the 1970s and have evolved thanks to research in various places. And it's good if you're getting serious about IP to at least have an appreciation of the research that's going on in the area of IP management and what it means. Change in direction again. In the IP sector, there are lots of different entities or players or companies or firms. The list is quite exhaustive. This list would have been very different if I'd given this presentation to you 20 years ago. There'd probably only 3 items listed. The national IP offices, which are the government bodies that regulate IP, companies that have an in-house IP function, and law firms that focus on IP. The rest didn't pretty much exist. But what we've seen in the world of IP has been an explosion in the number of entities in the IP sector. So if you're interested in playing the game of IP, very likely you will have to interact with some or many of these organizations. And just be aware that there's a variety of them out there. Even if you look at any one particular category, there's subcategories. So if you look, for example, at law firms who do IP, which is for Irish engineering companies, is likely to be one of your interfaces, that there'll be some firm out there who represents you when it comes to IP. But there are general law firms with an IP practice, there are large IP law firms, there are boutique IP law firms, there's one-man IP law firms. So which one is best for you? For example, if you decide I'm going to be interested in patents, I need to find a patent firm. Well, there's one down the road, I'll use that, but is that the right firm for you? Have they got skills and competencies in the area of technology relevant to you? If you are an Irish company exporting into the US, maybe your risks are in the US, maybe I need patents in the US rather than Ireland. Well, does my IP firm have the ability to get me patent protection in the US? So when you delve into this, there's quite a lot of these firms out there. You need to have a good sort of a due diligence approach to picking the right entity out there that's going to help and support you in the world of IP. The other thing that's happening, by the way, with these entities is we're seeing tremendous growth, lots of mergers and acquisitions, deregulation in most countries has allowed this to happen. And we're also beginning to see automation coming into the IP space. So the days of going into an IP firm and seeing paper folders and all over the place, they are disappearing. And most of these companies are now using sophisticated IT systems to help them automate or handle certain IP activities more efficiently and effectively. I mentioned one of the standard entities being companies own in-house IP departments. Even there as well, there'll be great variation. If you go to small or medium-sized Irish companies, more than likely there's no in-house IP function. Perhaps the bigger companies will have it, but even then they'll vary greatly in terms of their size, their skills, the way they're organized, how they operate and so forth. Moving to the subject of IP data. So I thought the best way to perhaps highlight this is to give you a case study. So some time ago, I was approached by an engineering company in Birmingham in the UK, a relatively small company, who were about to do collaboration with EDF, the big French multinational energy company. I should say I have got no relationship with EDF whatsoever. Never spoke to them, never worked with them, don't know anybody there. And the Birmingham company asked me, they said, Donald, we're aware you've got access to certain tools. Would you go and look at the IP data belonging to EDF and tell us what you can tell about them before we get into bed with them, basically? So we used a tool that basically pulled in a whole lot of IP data, all publicly available. And we presented sort of this information to Birmingham. I have changed it a little bit to hide some confidential information. But we were able to tell the following. We could first of all see how many patents EDF had. Then by looking at each patent, we could tell in which technology area the patent resided, whether it was in wind turbines or nuclear power or whatever. And by the size of the box and the color of the box gave an indication of the amount of activity by the EDF in that area and so forth, and the nature of what they were doing. By looking at the patents and their citations, we were able to tell, was EDF doing radical breakthrough innovation or incremental step improvements? Then by looking at the names of the inventors, we could tell who the key people in EDF were. But then jumping across to something like LinkedIn, we could tell, well, are these inventors all EDF employees or not? Or do they work for other companies? And we could see that in many cases, the inventors worked for other companies, which gave us an indication that these were EDF's existing collaboration partners. Because why would you have a patent with, let's say, two people's name on it, one an employee of EDF and one an employee of somebody else, unless they were collaborating? And then looking at the trademark data, and particularly the renewals of trademarks, we could see the countries where EDF were really, really interested in. So we went back to the Birmingham guys and said, well, as long as your technology is in one of those areas, and as long as some of those key inventors are across the table when you're collaborating with them, and as long as you're not worried about those collaboration partners being competitors of yours, this is what you should do with this data. I highlight this example to showcase the power of IP data, particularly when it comes to patents and trademarks. Obviously, there is no IP data or very little IP data available when it comes to things like trade secrets. Obviously, if you could see EDF's trade secrets through some public forum, then EDF have no trade secrets. I mentioned some trade secret data is available. For example, in court cases where there's trade secret disputes, sometimes you can get some insights as to the types of trade secrets in certain companies, but it's rather limited. You can also get from commercial sources trade secret valuation data. So there is places you can get stuff that might seem a little bit obscure. But hopefully this gives you a flavor as to the power of IP data. Now the sexy and exciting stuff. We're going to talk about the taxman. Now, why am I talking about the taxman? Well, interestingly, the tax authorities are quite interested in IP for two reasons. One is they recognize that they have a role and a responsibility in countries to promote innovation and creativity, perhaps not directly, but indirectly. And IP is, in some sense, a measure of the innovation and creativity taking place within certain companies. So you have things like the patent box tax regime in Ireland is called the Knowledge Development Box, which is a program to encourage particularly smaller companies to be innovative and to think about IP to protect that innovation. And similar schemes exist in many countries. I think there's about 15 European countries that have similar tax strategies to encourage innovation and creativity. However, the taxman is also aware that you can use IP for tax avoidance. You can misbehave. And unfortunately, Ireland does not have a good reputation here. At one stage, I think we were accused of being the worst country in the world for tax avoidance, using IP. So you can avoid paying tax using IP, unfortunately. And the tax authorities have woken up to this. So you have now got new rules, things like OECD BEPS and the EU Anti-Tax Avoidance Directive, which at first glance are very heavy tax documents, but when you read them, you're suddenly realizing you suddenly realize you're reading an IP management handbook. It's where the tax authorities are basically saying to companies, here's what we expect you to do, and here's what we expect you not to do from an IP management perspective. So OECD BEPS, I won't go into the details, is very much focused on who is the economic ownership, what is the economic ownership of IP rather than the legal ownership. Even though IP has been around for quite a while, I mentioned stuff from the Middle Ages and so forth, we are in a period of quite heavy turmoil in the world of IP. I've talked already about the changes. When I came into IP 20 plus years ago, I didn't have the same feeling that there was this turmoil, but clearly it has happened. We are in a period where there are lots of changes going on in IP rules. I've mentioned about patent reform in the US, trade secret law changes, copyright in the digital world. The center of gravity is moving east. We may think that we're in the Western world or leading innovation and creativity, but that's not what the data shows. If you look at IP data from China, particularly, but also Korea, Japan, even the emerging economies around China, they're dominating. They clearly are dominating. Yes, not everything is going perfect there, but the center of gravity when it comes to IP has moved east. And the West needs to wake up to that fact. And the answer isn't to moan, the answer is to become more innovative. Thirdly, there's a trend away from IP controlled by central registers, so registered forms of IP, to IP being controlled by agreements. We see that so trade secrets are a form of IP where agreements are key. It's not registered. Open source, it's depending on the agreements. Creative Commons, it's all about the agreements. Open access, it's all about the agreements. They're growing in importance. I'm not saying that patents and trademarks aren't important, but if you're only focused on the registered forms of IP, you're missing something. And then last but not least, so since the end of the Second World War up until about 10 years ago, the buzzword in IP was harmonization, reducing the differences from one country to another. However, in the last 10 years, we seem to have gone the opposite way. There's more fragmentation, differences from one jurisdiction to another as to how they approach IP, which is making IP more challenging. And there's lots of examples of that fragmentation at the moment. Last but not least, you need to have an IP strategy. Once you pull all this together, if your company is serious about IP, you need to have a plan. A strategy that will guide you when you're making decisions, hopefully align with your business. You should have a vision about where you want to go, but you need to have a strategy, which is a plan with goals. Your IP plan will not be a plan that lasts 2 or 3 hours or 2 or 3 days. It'll likely be a plan that lasts years, because changing the world of IP for your company takes time. So it'll be a long-term plan with some quick wins, short-term actions, mid-term actions, and so forth. And you'll need to adjust it from time to time because your company will look different 5 years from now. And maybe your IP plan needs to be adjusted accordingly. To have a good plan, you need to know where you are today. What is your position on the maturity ladder? Where are you in this relative value versus risks? What are your agreements saying that that are binding you in some way, shape, or form? What's your current portfolio of assets? So any plan starts with knowing where you are today. The plan will be made up of different elements and different operational, tactical, and strategic actions. I've changed the details, but this is an example of an IP strategy for a company in the UK we did some work with some time ago. You can see they have quite a lot of different elements or components to their IP strategy plan on the left-hand side. And then along the right, you can see some actions are more operational, some are more tactical, and some are more strategic. Ignore the actual text in the box. It's been modified to hide their identity. The most important thing is your IP strategy aligns with the business. Having an IP plan that bears no relationship to the business makes no sense. So it needs to align with the business in terms of it needs to support the business model, your product or services roadmap, what you're doing in innovation and creativity, what you're doing in your ecosystem with suppliers and collaborators and so forth. It may, depending on the size of your company, need to align with what you're doing with a finance and tax perspective. if your company is going through corporate events like an M&A, an investment round, IP needs to support you getting through those. And it needs to also align with your approach to risk. And your plan needs to be simple enough that people can understand it and detailed enough to have enough meat so that people know the detail of what's involved. Your plan will be unique to you, but there will be certain similarities with others at the same point in your lifestyle. So we do see similarities between IP strategies for startups that will differ from IP strategies for scale-up companies, and that will differ for companies that are incumbents, because what you're trying to achieve is different. I have links here to, I publish regularly about IP. My sister thinks I'm spamming people, but hopefully some of it's relevant. Feel free to link to me. There's some other stuff available from, there's a company called PatSnap, seem to publish a lot of interesting stuff. The patent office's websites are usually very, very good, although they tend to be focused on the registered forms of IP. If any of you are in engineering or more on the software side and open source, there's a colleague of mine, Martin Callanan in the UK, who writes some really good stuff about open source. There's a guy in Dublin, Raymond Hegarty, who writes a lot about IP strategy. And if some of you are more on the artistic side of engineering, Haley Bosher is a professor at a UK university who writes a lot about copyright and how that is of benefit to people in perhaps more the artistic industries.